Thank you and welcome again to the July docket here in Jackson, Tennessee for the Western section. We'll have our third case. Each side is entitled to 20 minutes. The appellant has a right to reserve time for rebuttal. If you do so when you introduce yourself or you're called. You may sit down, you may stand up, you may use a mask, but please do not approach the well. Stay where you are. And the panel you have this afternoon is becoming more and more important to introduce the panels because we're wearing masks and you might not know who we are, although our names are right here in front of you for easy convenience. But to my left and your right, from Shelby County, Tennessee, Judge Ross Dyer. And to my right, always my right-hand man and person, and to your left, from Shelby County, Judge Camille McMullen. I'm John Everett Williams from just up the road in Carroll County, Huntington, Tennessee. Call the next case, please.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. If you can hear me, I'm going to stay seated so I can stay close to the microphone and my notes. I'd like 4 minutes of rebuttal time.
Yes,
please.
sir.
Thank you. I'd like to start off with some the procedural history of this case. The defendant was pulled over for a broken tail light, and officers discovered that his license had been revoked due to his status as a habitual motor vehicle offender, also known as an HMVO. He was, along with several other offenses, he was charged and convicted of driving after being declared an HMVO, a Class E felony. At the sentencing hearing, all parties agreed that his sentencing range was 4 to 6 years, and the trial court imposed a sentence of 5 years incarceration, or 5 years. The court also stated at least twice that the $1,500 fine that had been imposed by the jury would stand. However, this case took a strange turn because the General Assembly repealed the entire part of the Tennessee Code dealing with habitual motor vehicle offenders. And that repeal became effective after the defendant had been convicted, but before he became sentenced, or before he was sentenced. At the sentencing hearing, the defendant pointed out this repeal, and he again pointed it out when he filed a motion for new trial, judgment of acquittal, or modification of sentence. The trial court then entered an order granting the defendant's motion and vacating his sentence and fine for the HMVO offense.
What was said at the sentencing hearing? If he filed the motion, if I understood you correctly, or pointed it out, I should say, at the sentencing hearing, hey, the statute's now gone. And then he then filed it as part of a motion for new trial. And that's the time at which the trial court did what he did as to why we're here today. What was the trial court's reasoning for not doing anything, or was it even discussed at the sentencing hearing?
It was discussed at the sentencing hearing, and the arguments were essentially presented the same way they were. The defendant argued this is somehow no penalty is a lesser penalty and you should get it. The state responded that there wasn't any penalty provided. And the court seemed to essentially say, we'll argue this out at the motion for new trial hearing.
So he passed on it at that point.
I think that's reasonable
Okay.
to say, Your Honor. But at the motion for new trial hearing, the trial court was swayed by the defendant's arguments, and he again entered an order granting the defendant's motion. Because that order was based on an erroneous interpretation of the saving statute, this court should reverse it and reinstate the defendant's sentence and fine. Now, the saving statute is what's critical here, and it's important to know what it does. It's divided into two different provisions that deal with the different ways the legislature can work on criminal offenses. The first provision deals with when the legislature addresses an offense itself. And it says that when the legislature repeals it, amends it, does something to the effect that it changes the offense, then you still prosecute that offense as it was codified at the time it was committed. So that's the first provision. The second provision deals with when the legislature does not reference the offense itself and instead modifies the.
Well, doesn't that statute just really codify a constitutional provision that you cannot make the elements of a crime less after a person has been charged with a crime? Isn't that the purpose behind that?
I think it encompasses the principle of an ex post facto ruling, but it also deals with a lesser punishment. So they're the two different.
Well, wait a minute. I thought you said there was two prongs.
Yes, Your Honor.
On the prong that you're talking about, the prong about changing the offense. We are just talking about changing the offense to be lessening the burden would be unfair on any defendant after the fact, would it not be?
Correct. It would also apply if they added an element or if they substantially change. It's principles of fairness to say that if they were to somehow modify an offense to lessen the burden on the state or to even add an element that wasn't there before, you prosecute an offense based on how it's codified at the time it's committed. So it's principles of fairness, I would say.
And if they have increased the punishment and added an element and increased the punishment, what punishment is the defendant to receive?
I think those are two separate actions, and the defendant wouldn't be affected by either. If they added an element, then they would have modified the offense, and the defendant would have been prosecuted as it was codified when he committed the offense. So that extra element would not apply to him.
Okay, so what would the sentence be?
The same sentence as it was before, because you're talking about
So
increasing.
they can't go up.
Correct.
All right. Now, what if they lessen the crime and lessen the punishment?
Then it would still be a whole new offense, and he would be tried and sentenced based on the old offense and the old punishment scheme for that offense.
If they lessen the burden and lessen the offense?
Because, yes, Your Honor, because they're not lessening the burden for the offense of which the defendant was convicted. At that point, if they say, we're going to create a new offense, we're going to lessen the burden, take an element out of an offense, and by taking that element out, we're going to change it from a C felony to an E felony. That's creating a whole separate offense that is effective from the time it comes into effect. It does not apply, the saving statute would not apply to that change. If that makes sense. And it's because as the Supreme Court, this came up recently in the theft with the amending of the theft statutes. And what our Supreme Court said in Menke is, if the legislature had in fact changed the offense of theft, if they had changed an essential element of what the offense is, then the saving statute wouldn't apply and defendants would not be entitled to a lesser penalty. The whole discussion in the theft cases was when you change the valuation and the punishment for that valuation, are you changing an essential element of what theft is, or are you simply changing the punishment and keeping theft the same? And the Supreme Court said, you're keeping theft the same, you're just changing the punishment. And when that's the case, the second provision of the saving statute applies. Here, the legislature did not do that. They modified the offense itself, and they modified it by repealing it. But they expressly did not provide for any lesser penalty.
Well, no penalty is less than some penalty, isn't it?
If they had provided for that, yes. If they had said, driving after being declared an HMVO offender is still a crime, but you get no jail time. If they had said that, they provided for it, then yes, the defendant would be entitled to it. But by being silent, they're inherently not providing for anything. And all they are doing is modifying the offense, in which case only the first provision of the saving statute applies.
So if our state went to the abolishment of the death penalty, and tomorrow abolished the death penalty in all capital cases, and said we're going to go strictly to life or life without parole, are all the people on death row, are they subject to death penalty?
I think there are interesting provisions about when the saving statute applies. I haven't thoroughly researched it, and I can follow a supplemental brief on when a defendant is entitled to it. This kind of came out in Tolley, where the defendant was convicted back in 2012, way before the amendments occurred, and our Supreme Court said no, then the saving statute would not apply. It seems to be that when the saving statute applies while the offense is being hashed out in the trial court. So I don't think that all of the inmates on death row would be entitled to that lesser penalty. But I think if the legislature were to say, for first-degree murder, you can no longer be subject to capital punishment. And there was a capital case that was in the pipeline, then they would have changed, they would have modified the punishment of the crime, and a defendant would be entitled to the lesser penalty.
And here we have, during the time period that you say the saving statute could apply, we have a situation where the legislature knows and knows full well that for years you could get 5 years for driving while an habitual motor vehicle offender in the state of Tennessee, correct?
Yes, Your Honor.
And they decided no longer will anybody in the state of Tennessee be subject to any punishment for this same conduct.
That's one way of looking at it. What they in effect did, and what they did based on their language, is they repealed the offense. They got rid of the offense. They did not say we're going to provide a lesser punishment for the individuals.
Well, once it's gone, isn't it?
Yes, Your Honor, but it's not retroactive. And that's where the saving statute would apply, is if they only provide a lesser penalty, then it could potentially be retroactive. But when they modify the offense, the whole provision, the whole purpose of the first provision is to say you don't make it retroactive and you prosecute an offense based on how it's codified at the time it's committed. So because the legislature repealed the entire statute, they didn't make it retroactive and say everyone who has been convicted of driving as an HMVO offender is also entitled to no punishment. They just repealed it from here forward. So because, again, the saving statute, based on the plain language and under the principles of statutory construction, we apply the plain language of the statute. And it says when the legislature provides for a lesser penalty and does not modify the offense itself, that's when the defendant is entitled to the lesser penalty.
There's something about due process and common sense that seems to, I wish to give full effect to what the legislature wants. And doesn't it sound a little bit offensive that the legislature decided that no one in the state of Tennessee should be prosecuted for this type of conduct? Yet we need to put a man in jail for 5 years for it?
Well, Your Honor, the legislature enacted this saying going forward, we're no longer going to prosecute. They didn't comment on people who had already been arrested, charged, and even convicted of the offense. And the saving statute only applies in that limited situation where the legislature does not modify the offense and instead modifies the punishment. Here again, because they repealed the entire statute, they didn't modify the punishment, they modified the offense. And the first provision of the saving statute applies, the second provision does not.
Do you think the saving statute is ambiguous at all?
No, Your Honor. The plain language is clear and straightforward. The Supreme Court, in analyzing the theft provisions, applied the de novo review and plain language of the statute. So it is.
So, okay. So then the defense in their brief cites to several portions of the legislative history and the record. Are we to consider that at all?
Not if this court agrees that the language of the saving statute is clear and unambiguous, which the state would submits, because the language is very clear. When an act is repealed or amended, first provision applies. When the punishment is what's changed it. But even if this court were to find that the language were ambiguous, looking at the legislative intent would not aid the defendant, because the legislature and the act that they passed repealing the HMVO part of the Tennessee Code expressly provided for lesser penalties in other offenses and did not do so here. So again, even if you go to the legislative intent and you look up the public act where they passed it, there are offenses where they decided an individual should be entitled to a lesser punishment. Just one off the top of my head is the failure to appear statute. It used to be an E felony, now it is an A misdemeanor. And they went in and affirmatively provided for that lesser punishment. When they got to the HMVO part, they did not. They simply said this is repeal.
So didn't they provide, though, in this case, implicitly provide for a lesser penalty by saying there is no longer a penalty for this because this offense no longer exists? I mean, if the offense no longer exists, there's no penalty for the offense. And so implicit in their repealing the act, isn't that what they said? There's now, and how does that defendant not therefore get the benefit of that?
Because such an interpretation would render the first provision null and void. It's irrelevant if you prosecute an offense based on the time, on how it's codified when it's committed, if there's no longer a punishment. If the saving statute always applies whenever a statute is repealed, then why would the legislature include the first provision that specifically contemplates a criminal statute or act being repealed?
Isn't the answer to your question to avoid absurd results based on changes that the legislature makes to laws? They're trying to avoid results that may occur as a result of those changes in the law. That's the original intent behind a criminal savings statute, a general criminal savings statute. Would you agree with me there?
Yes, Your Honor. The reason that they created these two separate provisions is to prevent absurd results. And to answer Judge Dyer's question is that if you interpret a repeal of a statute as inherently or implicitly providing for a lesser penalty, then you're nullifying the first provision. You're creating an absurd result where a defendant has to be prosecuted and has to be convicted for what could be a felony offense and yet receive no punishment, which would nullify why you prosecute an offense.
So the absurd, according to your argument, the absurd result is this defendant would have a felony on its record with no punishment attached to it, as opposed to the absurd result being, hey, the legislature doesn't want anybody punished for this crime anymore, and we're still punishing someone.
The absurd result would be, again, to nullify the saving statute.
Okay.
And while here, that might be what's the case. The interpretation would then nullify the first provision.
Okay.
So again, because the legislature did not expressly provide for a lesser punishment, and because, again, according to Menke, whenever the legislature starts adjusting the offense itself, the second provision of the saving statute does not apply. So again, the trial court erroneously applied the saving statute, and this court should reverse its order and reinstate the defendant's sentence and conviction.
You have your 4 minutes. Thank you, sir.
Thank you, Your Honor.
May it please the court, Brennan Wingirter on behalf of the appellee, Mr. Marvin Deberry, who is also here with me today. I'd like to start by clarifying a few things from the record before hopefully trying to clarify what is a very confusing and ambiguous situation we have with the saving statute. First, the state characterized the background of this case fairly accurately. I'll just add to that when Mr. Deberry was pulled over, he was driving to get to work. And that's very important because that is exactly the situation that the legislature spoke about on the record at sessions about why they changed this law.
So let me go ahead and ask you before, because it's clearly this is part of your argument. How is a saving statute ambiguous? I understand it is weird in this situation, but how is the wording of the statute ambiguous? Because
Well-
that's what gets you to, hey, here's what Senator so-and-so said, and here's what Representative so-and-so said. But if the wording itself is not ambiguous, we don't get there.
Of course. And I think that the point of the ambiguity in the saving statute has been made clear by the discussion between Your Honor and counsel for the state. The saving statute just says the legislature has to provide for a lesser penalty. Although the state has said it did not expressly provide for one here, as Judge Dyer, you pointed out, what if it could be implicitly provided for? It is not clear from the saving statute whether the legislature's provision for a lesser penalty has to be express or implicit. And when we look at the situation, when we look at the saving statute as applied to this situation, or as he mentioned, the theft cases, or as Judge William mentioned, what if we were talking about the death penalty? I think all of those instances illustrate why it is unclear and ambiguous. The fact that we're arguing about this today shows the ambiguity in that statute.
Well, I mean, so confession, I'm just troubled, I think, or interested, however you want to look at it in this case altogether. But because if being honest, I'm sitting here looking at it, nothing in this statute seems ambiguous to me. I can read the statute and I feel pretty confident, I may be wrong, but I feel pretty confident that I know exactly what the legislature is doing here. And so that's the window, the box we're in, is I look at the statute and go, I don't have a problem with any of the wording. It all makes sense to me. Okay, so it's not ambiguous. So the problem, though, that we have, and this is where I start to have my concern is, but when applied, it creates absurd results potentially. But that doesn't get us to what the legislature discussed in their hearings. It just gets us to a discussion on how do we as a court avoid absurd results, which is what the Supreme Court has told us we're supposed to try to do. So that's where I get your point that when you apply the statute, it could create weird situations. But I really want, if you can, and maybe you can't, maybe you agree with me at some level, what about the statute and the wording of the statute makes the statute ambiguous? Because again, as I look at statutory construction and statutory interpretation, I have to look at the words, and if the words don't make sense, that's when I have to go, okay, what did the legislature mean? And that's when I get to their history. The words in this statute make sense, do they not?
They do not, Your Honor.
Okay.
And I'll try to clarify. And admittedly, I was one of the attorneys in the theft cases, and I still don't know that I completely get it because
I was one of the judges on some of those theft cases.
It is
so, you know.
I was too.
it is complicated.
We're all very familiar.
So first, the express versus implicit provision is a problem. The more obvious problem as it is applied in this case is what this lesser penalty means, whether that means no penalty, it includes no penalty, or if it means lesser. Of course, we've argued that.
But we're talking about, but again, I'm sorry, I'm going to let you answer the
That's
question,
okay.
I promise. But we also look at the plain meaning of words. Lesser has a plain meaning. It's not some random word they just grabbed out of Webster's and threw down and we all go, what the heck does lesser mean? We all know what lesser means. It means it could be here, but it can be lower or smaller. Lesser doesn't necessarily mean, unless I'm wrong, zero.
But 0 is lesser than 5.
Okay.
So, and I think that's the point of disagreement here is if you take away his felony prison sentence, essentially you reduce it to a 0-year sentence. 0 is lesser than a 5-year sentence.
But it's not zero's not a penalty though.
That's correct, Your Honor. And we have not argued that the 0 is a penalty. Our argument is that
So the statute, I swear I'm going to shut up, but the statute says lesser penalty, 0 is not a penalty.
But
So lesser has to be 1. Just using your 5 and 0. I recognize there's lots of different penalties out there. It
Sure.
could be probation, this, that, and the other. But 5 to 1 or to a month or to something, because 0 is not a penalty, because I'm not serving anything if it's 0. So it has to be something, right?
Correct.
Okay.
And there is still a something,
All
which we discussed in our briefs, and I want to point out here again today. The state is saying that there are no longer any penalties at all for HMVO. And that's just not true. And we keep talking about, and I'm guilty of this too, we keep talking about a repeal of the HMVO law. I'm not sure that that's even accurate. I've got the Public Act pulled up right here, and it says that that part is amended by deleting a part and substituting instead the following. And the legislature put in that paragraph that we're all very familiar with at this point about what was supposed to happen through the Department of Safety after they got rid of the HMVO offense. What that paragraph does is say, you don't just, and I want to bring this back, Judge Williams, to your point about the death penalty. The legislature didn't say, okay, HMVO is gone. Now all of these people who have HMVO orders, you can go rip up that piece of paper. That is not what happened here. Anyone who has an HMVO order still has to go back to the trial court that issued that order and petition for a reinstatement of their license through the Department of Safety. Now, the state has argued that this paragraph where it says that the Department of Safety has to reissue the person's driver's license without restriction means there's no penalty, no fines associated with it. Our position is without restriction means without restriction on your ability to drive. I don't know of any situation where you can walk into the DMV and get a license without paying something. And in fact, in Mr. Deberry's situation, he's going to have to go back to the Haywood County Court and pay close to $200 in costs that they will not waive if he wants to have his driver's license reinstated. That's a penalty. And that's our position, is that he may not have the penalty of a 5-year felony prison sentence because the legislature has very clearly, if anything is expressed in this case, it is the legislature's intent that people who are driving to get to work should not be serving felony prison sentences for doing that. That is express. What penalties still remain may be administrative, they may be financial, but they're still penalties. They're things that he is penalized that I'm not. He has to do something to get out from underneath that HMVO order. No matter if we call this a repeal or an amendment to the statute, it did not just do away with those HMVO orders are out there. Like the death penalty analogy, someone convicted of first degree.
So does the statute, when it defines penalty, not just the code, not the statute, when our code defines penalty, does it talk about administrative fees as being penalties?
When we talk about sentencing in general, that includes prison sentences, misdemeanor jail sentences, costs, fines, the jury imposed fines, the jury recommended fines, all of that's included. Restitution, that's a financial penalty.
So the administrative fee to get your license back, if you're HMVO, is a penalty.
Yes.
Okay.
It is a penalty that anyone else who walked into the DMV to get a license would not have to pay.
So I pay $25 for my license or whatever the cost is.
Mm-hmm. While Mr. Deberry goes and pays $200.
Because he's got to pay the 25 plus the 200.
That's exactly right, Your Honor. That is a penalty. It may not be a prison sentence, but it is a penalty. And in addition, I want to talk about I want to finish up on that death penalty analogy.
Sorry.
Someone who is convicted of first-degree murder and is sentenced to death, if we got rid of the death penalty, they don't just walk out of prison. They're moved off of death row and into general population or maximum security. Same thing here. He can't just go rip up that HMVO order. He still has to take other steps. And what's interesting in this case is the trial court did not vacate Mr. Deberry's conviction. He has a Class C felony conviction on his record. And the state, in its original brief, argued that it would be an absurd result for a Class C felony conviction to stand without a corresponding felony prison sentence. But as we pointed out, the Attorney General in 2012 issued an opinion saying that if the legislature wants to punish a Class C felony offense with a fine, it can do so.
So what does the judgment look like?
I'm sorry, Your Honor?
So what does the judgment look like?
So the judgment is, I believe there was obviously an amended judgment. You mean, you referring to the amended judgment?
Well, let's suppose
Or
you're
the
right.
Okay.
What does it look like? What does a corrected judgment look like, assuming we agree with you? You understand what I'm saying? So you got an E felony. Does that just mean we write the fines? I mean, what does it look like?
So he has an E felony conviction, and then in the judge in this case, he didn't have to, but the judge did decide not to impose the $1,500 fine. He could have, and we've argued that separately, that the discretion on the fine is different than the sentence. But the judge also vacated that fine, and in the special conditions box said that his sentence was vacated pending appellate review, is where we stand right now.
Okay, so what does a valid judgment look like in these circumstances? Because this is, again, unusual.
Of course.
So a valid judgment would be keeping the E felony and no imprisonment?
That's correct, Your Honor.
And that's it?
That's correct. And that it is that simple, and that is exactly what the legislature has intended. 2 points that the Attorney General's opinion from 2012 make that they're highly relevant here. One is that it is not an absurd result to have a Class C felony conviction with no prison sentence. We allow that in certain circumstances. Here, it wasn't expressly done ahead of time. It was done later by the legislature. And the legislature, in getting rid of that felony sentence, exercised its authority as the legislature to make a decision about what an appropriate punishment should be. And that same Attorney General opinion from 2012 expressly recognized that the judgment as far as an appropriate punishment for an offense is left in the first instance to the legislature. And here our legislature has very clearly spoken, we don't want to be sending these people to prison anymore.
So what class E do we give no sentence for?
I apologize, my screen just timed out. I have them, I listed them in the brief. I believe there were 3 or 4 expressly cited in that 2012 AG opinion that I'm not going to be able to recall off the top of my head. I
I've got your
apologize.
brief right here. It's fine.
But we did list them in there.
Okay.
And so what we argued in our brief was that here, this isn't something like those that the legislature did ahead of time. But the point of listing those offenses was that the state had argued that leaving the conviction without the sentence was absurd. Our point is, it's not absurd. The legislature can do what it wants as far as sentencing. And here, the legislature has expressed its very clear intent that it does not want to send people like Mr. Deberry to prison anymore. As far as the distinction between whether the repeal was of the offense or the sentencing, again, I think we need to be careful with that word repeal. And I would again point out, Mr. Deberry was prosecuted for the HMVO offense as it existed at the time it was committed. And that conviction, as of now, still stands. All the trial court did in this case was exactly what it was supposed to do, follow the intent of the legislature in terms of an appropriate sentence. And the legislature didn't just say, we're doing away with this. I hope that the court will get to the legislative history through finding that the saving statute is not clear and unambiguous, because it is so explicit in those session statements that the legislature was trying to save the state of Tennessee nearly $14 million by reducing these penalties for low-level driving offenses. Mr. Deberry was not just driving to work, he was driving sober, he was drug-free, he cooperated with police. He's exactly the person that they talk about this amendment being designed for. And what the state is asking this court to do is say that the saving statute is so clear, despite all of the recent litigation that we've had on this issue going all the way up to the Tennessee Supreme Court, which still doesn't answer the question in this particular case. Say that it's clear and completely ignore the will of the legislature. We're asking this court to affirm the trial court because it did follow the will of the legislature and is the legislature's position to set sentences in our state.
So it's, by the way, failure for a sex offender to obtain photo identification, shipment of wine without a license, and then commission of some particular form of communication.
Thank you,
so
Your
Honor. So if I understood what you just said, though, even assuming the saving statute is completely clear, we're supposed to then ignore case law and go to the legislative history, even though we think it's clear? Did I misunderstand?
No, Your
okay.
Honor, I did not mean to imply that. No. First, the saving statute is not clear, and that's how we'd get to the legislative history. If the court were to find that the saving statute is clear and unambiguous, you can still find that, just as the trial court did, that no prison sentence is a lesser penalty.
Okay.
And so either way, we've provided 4 or 5 different avenues in the brief for the court to reach that result. And either way that the court goes, the result in this case should be the same to affirm. One other thing I wanted just to clarify on the record, at the original sentencing hearing that you asked about, Judge Dyer, the only comment by the ADA at that point was that the repeal to the HMVO law had not taken effect until July 1. There was no discussion of the no penalty, lesser penalty at the original sentencing hearing. The HMVO law was mentioned. There was a minor comment of, does it apply, does it not apply, because of the timing. Now there's no dispute as to the timing. We know that it was amended while this case was active. And then all of the no penalty, lesser penalty came up at the subsequent hearing. So
Thank
to
you.
clarify that. Thank you, Your Honors.
Thank you. You have your floor.
Try to respond to all the points that the defendant made. First of all, Judge Dyer, you're saying for a lesser, there must still be something. It goes back to the principle that the Supreme Court established in Menke, where there are the different provisions of the saving statutes apply to two different actions. One is where they provide a lesser penalty, where that offense is still there and they do something where there's still a punishment. And then the first provision is where they repeal or amend, or however you want to call it, when they modify the offense itself. And the Supreme Court said, when they modify the offense itself, repeal, amend, again, however you want to call it, then the saving statute, the second provision of it, does not apply. So
are you suggesting that if the legislature just said there is no punishment for driving on habitual motor vehicle order, Mr. Berry's judgment is correct?
yes, Your Honor, if the legislature comes in and says, we're not changing the offense of driving, having been declared an HMV, what we're saying is you don't get punished anymore for that. It's still an offense, you just don't get punished. Then the judgment is correct.
If they come in and say, we don't want anybody in the state of Tennessee prosecuted for this behavior again, this man needs to serve 5 years.
If they say that, then the first provision of the saving statute is blatantly clear that they have modified or amended that offense, and that when an offense is committed, it has to be prosecuted as it's codified. It was an offense, a criminal offense at that time, even though the legislature has changed it since then, and it has to be prosecuted at that time.
So in this case, then, we prosecute it as it was, and we send it back. We say the trial court was wrong in doing that. Can he then impose a 1-year sentence and do away with all the fines?
No and yes, Your Honor. There are still legal avenues the defendant can seek. It cannot be based on the saving statute, but the trial court, to the point that the trial court refused to impose the fine, it did so. It abused its discretion, but it could, if we go back and for some reason allow the court another stab at it, which is not necessary because this all came out after the sentencing hearing. But if we go back, the trial court can lower the fine. It can only modify his sentence down to 4 years because his range is 4 to 6 years.
I misunderstood that.
Briefly,
I got
I want
used to my one answer from over there. I apologize.
I want to briefly cover a couple of things. Court costs are not considered punishments. They're administrative fees and things, but they are not considered a punishment for a criminal offense. The defense counsel referenced the AG opinion, and I think she explicitly said the legislature can do whatever they want to do. But on all of the felonies that they changed, that you pointed out, Judge Dyer, they specifically provided for a lesser penalty and said, this is an E felony that is punishable by fine only, or something of that effect. Again, if the legislature had done that here, this would 100% apply. The second provision of the saving statute would, and the lesser punishment would be there. And then lastly, to your answer, Judge McMullen, I think you were asking what this physical judgment looks like. And if that's the case, it lists out the charged offense, which is the Class E felony, the convicted offense, which is the Class E felony. And then when it says punishment, it is entirely blank. So again, because the court incorrectly applied the saving statute and gave a lesser penalty where the legislature did not provide for one, it abused its discretion. The defendant's sentence and fine should be reinstated. And if there are no further questions, we ask that the court do that.
Okay. I thank both of you for the issues joined today, are very well presented, and we'll stand adjourned to the call of the next case.